Hello. So with your permission, ma'am, shall we begin?
We shall. I'm excited to start our session today.
Okay, so very good morning, ma'am, Honorable Christy Harrington, ma'am, and very good evening to one and all present here. I am Abhijit More and I am taking this opportunity to welcome you all for the fourth lecture of this special lecture series on topic Mediation and Conciliation Recent Development, organized by Maharashtra National Law University, Mumbai and the Family Court Bar Association. Judge Harrington, ma'am, retired from the South Carolina Circuit Bench after serving for the 2 terms. Ma'am is a certified South Carolina Supreme Court mediator and arbitrator, owning her own alternate dispute resolution practice, Christy Harrington Dispute Resolution. She has completed her 40-hour mediation training at the National Judicial College in Reno, Nevada, and she is on the judicial panel of American Arbitration Association. She is currently the member of Arbitral Women, South Carolina Bar ADR Section, and South Carolina Bar International Law Committee. She volunteers with the Charleston Mediation Center, mediating various civil matters. Thank you so much, ma'am, for the last 3 wonderful lectures. Now we are awaiting for the fourth one. Over to you, ma'am.
All right. Well, good evening, and thank you for having me once again. I really enjoyed these sessions. What I want to focus on today is getting your client ready. We've been talking about the process and how to get yourself ready as a advocate and a counselor, and how to get your mediator ready. But I think it's useful for us to spend some time on getting your client in the mindset to mediate the case. And so what you want to think about is, how is your client doing? This is a moment when the marriage certificate, you're ripping that up, you're dissolving the home, taking the children into a different environment. So really what I suggest is for you to take this time prior to the mediation and really check in with your client. Think about what you can do to help your client through the process, whatever that process looks like. And by you helping, you're also then helping the mediator to control that process. Remember, you'll hear me say mediation, the mediator controls the process, the parties control the outcome. But if you don't have a good mediator that understands the process, and part of the process is these clients and the emotions that come through, you're going to have a hard time getting the outcome that you know your client wants and deserves. So think about what you can do to help the client ease tensions. Remember, and I think this goes for almost every attorney in every practice area of the law, clients typically don't come to attorneys because they're having a great day. They typically go to attorneys because this is the worst time of their lives. Whether you're handling criminal matters or probate matters, this typically is not a happy time that your client is going through. So knowing how to deal with emotions, and I think that is very difficult. Most attorneys are thinkers. We look at situations very black and white, and when we have a client that comes to us and is very angry or crying, it really is difficult for us to move past that thinking and move more into a feeling or a sensing. So you need to have that conversation with your client, litigation versus settlement. And I really like thinking about a result versus a resolution. So reframing those issues. So litigation, you're going to get a result. That is guaranteed. There's going to be some outcome in litigation. The judge is going to make a determination. In certain cases in the United States, a jury makes the determination. So you're going to have a result. But think about a settlement in terms of a resolution. And when you're talking to your client about a resolution, doesn't that sound more productive and positive than a result? Because you cannot guarantee the result, but you can guarantee the resolution. So starting this discussion early with your client, I think really helps reframe and put a positive spin on the situation. I like this where you've got a decision. Are we going to go forward? Where are we going to go to the left and are we going to litigate? Or are we going to prepare this case for a settlement for that very positive resolution that we just talked about? And I think when sometimes there'll be a fork in the road where clearly you've got to make that decision where settlement is not an option for whatever reason. But if you can spend the time at this juncture, at this point in the case, deciding, are we preparing for litigation or are we preparing for resolution? So I think timing is everything, and every case is different. When do you decide to mediate? When do you decide that mediation is not going to be productive? When do you decide to go to court? I'll see you in court is that famous saying in all the movies and or John Grisham novels, when the protagonist gets angry and things aren't going their way, I'll just see you in court. So this may depend on a variety of things. And remember that the number one cause of conflict is change. And think about when you're preparing your client, how has this case changed your client? So go through, just take a moment, and I want you to think about a client that pops into your head and think about what prompted that client to come into your office. What was that change? And how did that change affect your client? So keeping that client in your mind as we work through some of these exercises today, I think would be helpful. So is there going to be any exchange of information? Should there be a discussion of discovery? Do you want to have some exchange of information because you know you have a good case? Do you need some information provided to you to help strengthen your case? Is there going to be costs associated with this information exchange? So are you going to take a deposition? Are there going to be interrogatories exchanged? What's the cost associated with those? And cost doesn't necessarily have to mean that they are dollar costs. They could be time costs. They could be emotional costs. So keep in mind what these costs are going to be. Do the parties need to experience litigation fatigue? And what does that mean? What is litigation fatigue? Having to go to court and sit and wait for a motion hearing, having the bill from the attorney come to them, knowing that they have to wait a particular length of time before they even get in front of the judge, this case dragging on. And I think particularly in recent times with COVID, that has extended even further. So courts were completely shut down for a while, I think globally, and there now, because of that shutdown, there are numerous delays in most jurisdictions, South Carolina, even one of them, and I know India also has these backlogs. And so this litigation fatigue, when is it ever going to end? So sometimes your parties need to have an experience, a taste what it's going to be like to keep waiting. If you mediate too soon, there may be a potential not to take the mediation, not to take this opportunity to resolve as seriously as they could. I found when I was on the bench that the minute we set a court date, that prompted settlement, because parties start thinking about getting ready for court and realize what they need to do in order to make that happen. So think about, when is your court date? Would it be potentially helpful to have the court set a date in the future so that you know what your timeline is? And again, always thinking about the cost. What is the cost for the attorney? What's going to be the cost if mom and dad are going to court and we need to get a babysitter or someone else to watch the children? What are the costs to take off work? All of those things that add up aren't necessarily things that we think about when we talk about litigation costs, but these are things that having that very frank and candid conversation with your client, it's not forcing them to enter into a settlement. It is helping them realize what is in their best interest. And remember that phrase, result versus resolution. Wouldn't it be better to have that resolution that addresses all of these issues instead of just a result that you can't control? Remember, we talked about that the process, right? The mediator controls the process, the parties control the outcome, and that a good mediator will talk about attacking the problem and solving the problem, not attacking the person. So think about when your client comes to you and says, my husband is a very bad man, or my wife has been very mean to me. This is going to be hard. So when you begin to talk with your client, try not to attach values to court is good, mediation is bad, the judge is going to be very mean, the mediator is very nice. So having those just very candid conversations also helps to avoid attaching values. Think about reframing when you're talking to your client. Just because someone, for example, doesn't pay child support, that doesn't make that a horrible person or a good person. It's simply someone who did not pay their child support. And keeping this a very neutral conversation really helps start your client to think about the perspective and achieve this resolution. Develop options for mutual gain. And I think that this is where mediation really has the benefit over litigation and even arbitration if there's that option. How can you get your client to start helping you develop alternatives for this resolution? What questions are you going to ask your client to start brainstorming? So here's our discussion question on this topic, and I'd like to hear from somebody that had a question or you thought of a good question that will help your client develop an alternative solution. So in family court cases, it's really easy to say wife is going to pay husband and they're going to split the children visitation 50-50. And they'll alternate holidays. So that's a real simple solution. But what if that doesn't work? What if your client says that I'm not going to be able to do that? Has anybody had an opportunity or a situation where you were coming up with these alternatives and you asked a question that really helped your client develop an alternative solution? And just feel free to unmute yourself or put it in the chat. Mr. Moore, if you could help me, it's hard to see the chat and the PowerPoint, so.
Yes, ma'am. I will let you know.
All right. And maybe you had a question, you asked your client something and it entrenched them even more. Maybe a question, maybe ask it that way. I think a good starting question is always, why do you want this case to resolve? What is your purpose for resolving this case? And so by having the client tell you why they want to, their why, that will help you begin to help them develop alternative solutions. Remember, just as I was stressing, this is not the mediator's case. You are an advocate. You're there to help the client come up with an alternative solution or to achieve resolution in their best interest. So sometimes it's helpful to have an outside perspective to help come up with some of these alternatives. So hiring a tax professional to help understand what the awarding of alimony may do, or a home appraiser to evaluate how much equity there may be in the family home. Remember, at mediation, you get to enlarge the options. We call it adding to the pie. So we can slice the pie different ways, right? It's how are we going to slice it so that people can get bigger pieces? So thinking about those alternative solutions and alternative options that we talked about in the last slide is really important. Having your client tell you, well, this is the purpose, my why for resolving this case is because I need $1 million. And asking the client, how did you arrive at that number? Often that will help you establish the credibility, meaning the realistic objectivity of that number. And so all of us can pull a number out of the air, but if we don't have a realistic basis, it's really hard to establish that at mediation, and definitely very difficult if you don't have that number based in fact in litigation. And so talking to your client about, well, I understand you may want $1 million, but your home only appraised for $100,000. Where is that extra $900,000 going to come from? And that helps the client understand my numbers are not realistic. They may not like it. They may still want that $1 million, but showing them these options and this objective material is very helpful. So the home appraiser doesn't have what we say, we don't have a dog in the fight. So the home appraiser is a neutral party that comes in and shows the numbers and making sure that you have that how that appraiser, how that tax professional got to that number is so important. So we talk about BATNA, and that is best alternative to a negotiated settlement. And then the alternative is the worst alternative to a negotiated settlement. So best alternative to a negotiated settlement is perhaps you're going to continue on to trial and you get a jury verdict in the amount that you want. That's your best alternative to a negotiated settlement. So asking your client and knowing your client, knowing that there are some things that would encourage your client to settle. So what would be some of those things that would encourage your client to settle? So thinking, so in South Carolina, you have to be separated for 1 year before, in most cases, there are some exceptions, before you can go in front of a judge and have your divorce finalized. And so some of the things that would encourage in that case is that if an individual had found somebody else and wanted to get remarried, so encouraging this resolution before that 1 year, knowing that your client wants to move to a different state or a different country for whatever reason, that could potentially encourage your client to settle. So there's a variety of things that you may not know, and asking those questions and having a really good relationship with your client can help you encourage your client to settle. So knowing that your client does not want to go to court, that there's something that your client potentially does not want to say to the judge or does not want the jury to hear about their company or whatever, they do not want to go to court, because letting them know, though, if we don't settle, if we don't resolve today, it's going to go to court, and that jury is going to hear that one thing that you don't want them to hear. So keeping in mind, what is your best alternative to a negotiated settlement, and what's your worst alternative? And typically, when you're thinking about the worst alternatives, they're usually a lot worse than whatever a best alternative could be. Again, remember, you are focused on your client's interest, not on their position. So think about when somebody says, I want the house. What are they really saying? That I want the house. Think about the interest behind the position. What is motivating that individual to say, I want the house? Perhaps they want the house because they have a beautiful garden in the backyard and they don't want to give that up. Or it's near to all of their friends, or the children have grown up and they've got those height markers on the kitchen wall and they don't want to leave. There's a lot of sentimental values. That's their interest. So maybe if you know that your client doesn't necessarily want the house, they want to be in that neighborhood, or they want to have access to this garden, then that's where you can focus on getting to your BATNA, getting to this resolution, understanding the interest behind the position. It's easy for everybody to say, I want the house, I want the car, I want this confidentiality agreement. But when you understand as the advocate, it becomes easier, because then you open up all these other possibilities. My client does want the house, but is more concerned about giving access to the garden, and potentially then you can create a settlement that is amenable to everyone's interest. And so it's harder to negotiate, I want the house, because that gives you no other alternatives other than it's a house or nothing. So we all have different conflict resolution, and we may have different conflict resolution styles within the conflict. The most common types are avoidance, where someone just walks away from the problem. We have denial, where the person just does not even admit that there is a problem. Confrontation, so argumentative, right? And this is somewhat where we think of the bully at the mediation table. Competition, where you have to be, the person has to win. And I think I started talking about lectures a couple of times ago, arguing over a lamp or the family pet. And so it's not so much that I want the lamp, it is that I don't want anybody else to get the lamp. And so this thought of competition, this win at all costs. Then there's a conflict resolution where you're compromising. And then there's the conflict style of collaboration where you're working together to solve the problem, to resolve the conflict. And so which style do you think is better for litigation? Anybody have a thought on which conflict resolution style is better for litigation and why? Or for mediation?
For litigation, it may be denial, and for mediation, it may be compromise and collaboration.
All right. And why do you think that compromise and collaboration would be helpful in mediation?
Because we want to protect the harmonious relationship between the parties, and that could be done only if you are either compromising or you are collaborating in order to settle the dispute.
All right. Great. I think that's spot on, right? And what do you think would be one of the worst styles for mediation?
Maybe confrontation or denial.
Yes. And so,
in my opinion, it could be a competition. Sorry?
Yes. And why do you think competition is not useful for mediation?
It's not useful because if both the parties want to have edge over each other, then they would not come to any amicable solution, or things would not get as smooth for mediation. So avoiding competition during conflict resolution would be in good concern or interest of both the parties.
So what are you going to do if you have a person at the mediation that their conflict resolution style is confrontation? How do you handle that as an advocate?
If the parties want to confront, I would sometimes let it out, so that at times when you confront things, it vents out whatever frustration parties have, and then whatever probable impasse would not come. And there are some times when parties want to talk it out and they don't find a common background or a platform to talk, because in court it is all recorded or it is all on papers. But in mediation, probably this would help them to ease out or bring some relation, smoother out things, I feel.
Excellent. I think all of those are great points. Do you ever think about what your client's conflict resolution style is before you go to mediation or to court?
I do sometimes, because I know what my client wants. So as you just suggested, we try to give them a realistic view of what could be a possibility in mediation, because you just cannot have a mountain when somebody is offering you a something small pieces. So I prepare my client when we go for mediation as to be very realistic and be open-minded, so that whatever offers, and do not immediately come to any compromise, but think before you give your final, how is benefited, how it is not. So that is my normally an approach or advice to my client.
That's an excellent conversation to have, because I think too, when you look at compromise, that looks like, oh, that's amazing, and that would be great to have at the table. But just as you pointed out, sometimes people that want to compromise just to get things over, they end up agreeing to things that they're going to potentially regret later, or as we'll talk later today, is the settlement agreement going to be enforceable? Are they going to be able to do what they promised? And so really what we're hoping to get our client to and to be present at mediation is this collaborative style. And so being able to compromise is certainly very important, and having that, but really collaborating to come to this resolution. So what are some ways that you, if you have an avoider or someone who is in denial, that you think you could help them move towards resolution, move towards more of a collaborative style? Any thoughts on that, or anyone have a story or that something, the technique that they've used? So again, I think, we've talked about that question, what will your tomorrow look like if this doesn't resolve today? If there's not a resolution, you can avoid this, but there's a court date in the future. And so sometimes having that court date, especially for your client who is going to keep avoiding and keep avoiding. And I get a sense of a client who is going to avoid when they call, attorneys call to schedule a mediation with me, and then they cancel at the last minute, or their client doesn't show up, that they're just avoiding any situations that involve this case. And having that very candid conversation, again, that this is going to be the day. It is set for a trial where you're going to have to go to court on April the 1st, and if you're not there, this could potentially be the ramifications and whatever those could be. And so, there are certain cases where if that party does not show up, the case doesn't go away. The case may be decided on default, and then that certainly is not a BATNA. It is the worst alternative for that client. Getting a client who is in denial about all of these things. And so we all can talk about and have talked and heard about trauma and how that affects the brain's processes. So there's a wonderful TED Talk by Dr. Nadine Burke-Harris, and she talks about the effects of trauma and adverse experiences on the brain, and how people have a really hard time answering questions and dealing with things. So again, encouraging your client, maybe showing a court document that truly the spouse has filed paperwork, that black and white, you cannot deny that this is happening, and encouraging that this is the opportunity that they can stand up and take authority over what the next step is going to be like. Confrontation is something that you're going to need to work on with your client. Sometimes explosive anger, an outburst, if you know that's going to happen, please advise your mediator. And but having those discussions with your client that certain behavior is not going to be tolerated, and if they are not able to engage in productive discussions, they're going to lose the opportunity to enter into this resolution. I like, again, competition. We've talked about this before. I think all attorneys are very competitive, especially trial attorneys, this win at all cost type of mentality. And that is not what mediation is or should be. And so having that conversation that mediation is this opportunity for you to have an opportunity to resolve this matter. And so framing the issue for that competitive conflict resolution style, that you are defeating the problem. And maybe if money is a motivator, or then you can talk about, hey, if we can engage in mediation, you're going to save on this much money in litigation costs, and making that the problem that that individual is beating, not that it is I get the lamp and only I get the lamp. And so defeating the problem, not the person, is really important reframing for the competition conflict style. Knowing what your client is afraid of, and I think this is really important. Is your client afraid of the courtroom? Is your client afraid of what might happen? If you think that your client is going to compromise because he or she does not want this case to end up in front of a judge, maybe taking your client to observe a court proceeding, or just walking to the courthouse steps, so that you have empowered your client so that they're not making the decision based solely upon a fear of the courtroom. If your client is afraid of the opposing party, then having that discussion with the mediator about keeping your client separated throughout the mediation process, or maybe one can appear by phone or Zoom, and so that will alleviate some of your client's fears. Having that conversation with your client, if they're truly afraid of the opposing party, that can be something that you can discuss. We can control what happens here today, but the judge is going to want to see both of you in her courtroom. And so outlining what potentially could happen, what the client gets to control and when, could potentially be that one thing that helps move that from a denial or an avoidance into a collaboration, conflict resolution. Having a discussion with the process so that your client knows this is going to happen. I think it is wonderful, and I see when clients are really prepared by their counsel, when we go into a mediation, that it happens the way that they have been told it's going to happen, they start to relax. And so explaining the process is really important. And that goes, even if it doesn't resolve at mediation, having that conversation with your client, what the process of court looks like, is really important. Having a fear, sometimes your client doesn't even know what they're afraid of. And so they may be afraid of the unknown. They may be afraid of what their life is going to look like once this divorce takes place, once the settlement is reached. And so knowing what your client is afraid of and knowing how to help that client work through those. So remember, change causes people to react in various ways: anger, fear. So knowing, asking your client, what would you like to see happen here today? Sometimes as the mediator, I'll ask that, what would you like to see happen here today, so that you know what your client wants to happen, but you've heard it from his or her own perspective. I'd like to see this case resolved today, and then maybe follow up with, why would you like to see that happen here today? Why wouldn't you want to wait and let the judge make that decision? Having those follow-up questions are really important. Knowing that you are communicating effectively with your client is really important. And so think just a moment, I asked you to think about that one client that at the beginning of our lecture here today. was there something preventing you from effectively communicating with that client? So I think what we'll talk about today is where does your client, is that person going to be sitting at the table, and how does that affect what that conversation may look like? So I just picked two very common styles of conference tables. One is a round table, and one is your typical conference table with somebody at the head of the table, sometimes two people at the head of the table, and then chairs on either side. So when you are interviewing your client, a lot of times you're going to be behind a desk, and so there's going to be something in between you. Ask yourself, where do you think your client would be most comfortable? So where do you think, at a round table or this long conference table, do you think your client is going to be most comfortable in a mediation process? Any thoughts? Or does it matter? Does it matter what kind of table your client is sitting at during a mediation? Does it matter where your client sits? Has anybody gone to a mediation and the mediator has already placed where and told you where to sit? Mr. Moore, do we have anything in the chat?
Yes, ma'am. I think Rajeshri saying the round table.
All right. And so I saw that one pop up, the client should not feel cornered. And I think that's, so one of the things, one of the reasons why I picked this rectangular table is that room seems very closed to me. There's no windows. The round table appears to have some sunlight, but this, so what I do before mediation is I go into the conference room. I either use mine or I'll go to the attorney's spot, and I'll make sure that the tables are even and equally distributed. But in this particular, the rectangle conference room, the people on the far wall are going to have a hard time getting out, right? Are they going to feel trapped? And so think about, who's going to sit at the head of the table, at the two ends of the table? And so there's a lot, the person that trained me in mediation calls it psychogeography. And where you are placed really does have importance. So at the round table, we typically think of a round table as being very collaborative, and there's no head of the table. Everybody can have some space. This room particularly looks more inviting. It's larger, has other chairs around it, and does have some windows. So think about, too, where you're going to have your mediation and what type of conflict resolution style does your client have? So sitting at a round table is going to encourage more collaboration. Sitting at the traditional head of the table model may be something that encourages a more competitive conflict resolution style. So be thinking about, especially as you're preparing your client, do you know where you're going to be having your mediation? If you come in, does the mediator already have the chairs lined out as to where people are sitting? Who gets to make that decision about where people are sitting? So using what you do know about the conflict resolution style and this placement at the table can be very effective. So think about how these statements are going to affect mediation. And I like that very great comment in the chat that the round table does keep and indicates that everybody's going to get equal treatment. There's not a head of the table. There's not somebody that's at the lower end. And so there's nobody closer to the mediator, so they're not going to get special treatment. So keeping those things in mind is really, really helpful, and spending some time talking to your mediator about your client and what you think would be helpful is important. So at the conference place where I have my space, I have the availability of a large conference table like the one on the right. I also have some smaller round tables. Sometimes I use that for the caucus so that we're all on equal footing, right? That there's nobody at the head of the table, so to speak. And one of the worst things that can happen, and I've seen it happen, and it's really important that your mediator controls the process, is if you have somebody that's competitive and they walk into a room and the seats have not been assigned and the mediator doesn't control it, where do you think that competitive person's going to sit at the mediation? They're going to sit at the head of the table. And then what are you going to do? How else are you going to place the people? And so keeping all of those things in mind, and if you go to a mediation and those things are occurring, perhaps it's appropriate to ask to speak to the mediator outside the presence of everybody else and say, I really appreciate this beautiful conference table, but perhaps we could reconsider the seating arrangements. I feel that my client is at a disadvantage since he is not at the head of the table, an opposing party is. Great comments. So thinking about just these statements and how they are going to affect mediation. So in each of these scenarios, the client is asking for $100,000. In the first statement, I want $100,000 to pay for the damage to my home and to compensate, for my loss. In the second statement, I asked for $100,000 to get this case resolved. What conflict style do you think that is? Any thoughts? We have the conflict styles that we've talked about. Does that sound potentially like that could be a compromise? I'm going to do this just to get this case resolved. The third statement, I asked for $100,000 because I want my damage to be acknowledged. So thinking about all of those statements, I want $100,000 to pay for my damage to my home and to compensate for my loss. That's a pretty non-emotional statement. I asked for $100,000 to get this case resolved. Pretty factual and indicates compromise. I asked for $100,000 because I want my damage to be acknowledged. Comes from a place where your client is going to has some emotional needs that need to be addressed. And so again, when we think about attorneys being thinkers, not necessarily feelers, not always addressing the emotional side, there is no place for emotion typically in the law. We learned that in law school. And so dealing with these three statements, you're going to have to talk to your client in different terms, and you're going to have to acknowledge the motivation that your client has for these. So think about those biases. So you're a thinker and your client says to you, I want $100,000 because I want my damage to be acknowledged, is that going to affect your discussions with the client? Are you going to have, is that going to affect your discussions in the mediations? Are you going to be sending these implicit biases, these signals about this comment your client made to the mediator? Or is the mediator going to then pick up on this bias, potentially, that your client is emotional? Has anybody had a bias impact a settlement, either by the mediator or by opposing counsel or opposing parties? So we've talked a little bit about bias. We touched on that in a previous lecture. And so, bias in a domestic case here in South Carolina would be that the female needs financial assistance and is going to be in a worse position because of this dissolution of marriage. A very common bias, and one that has actually been written into our law, and we are working to get away from that, is that the mom is the better parent to place the children. And so these are all biases, and very likely still occurring. These biases are still occurring in mediations that are happening today in South Carolina, where custody may be an issue, and mediators, based upon their own beliefs and perceptions, or how you as the counsel are presenting your client, those could potentially still impact how your settlement comes out. So maybe you represent the father, and he's actually the person with whom the children's best interests are in trust and should be maintained in that home. But because your mediator has a bias against fathers having custody, or because you have allowed some of your own biases to affect how the solution needs to work. So think about what we all have biases, and we talk about the difference between implicit and explicit. A lot of times our implicit biases, they're subconscious and we don't even know that they're happening. Our explicit biases are things that we share out loud. Like, I don't think women should get divorced, or fathers should only see their children on the weekends. Whatever your bias is, are those affecting how you help your client get to this resolution? And maybe your client has some biases about what's happening. Maybe they have traditional cultural norms, and those are going to impact the settlement as well. So being aware of your bias really is going to help you get the solution that works for your client. I love the difference in talking about listening. I feel that lawyers are listening only to respond. And what does that mean? So we're trained to listen, especially trial attorneys. We are not hearing what people say. We're listening to respond to what is being said. And so spending the time, and it takes work. It takes work to listen and to actually hear what's being said. So take a moment, and I want you to think of, and don't share this one out loud, is there someone to whom you do not listen when they speak? Maybe it's a coworker, maybe it's a relative. Is there someone when you hear them speaking that you don't listen? And think about what happens when you're not listening to them. And what are you doing when they're speaking and instead of listening? So what happens when you do not listen? What happens when you're not paying attention to what your client is telling you? Well, this is where having implicit bias or explicit bias really can play a large impact, because you might already know what you think is in the best interest for your client based upon their outward appearance or what they've said to you or what you think should happen. And then they start talking and they're telling you their story and telling you what happened to them. And maybe you stop listening. You're nodding your head, but you're thinking about so many other things other than what your client is sharing with you. And you're going to, that is exactly correct. You're going to miss some important points. You're going to, those are the things when your client is talking to you, you've got to hear them. You've got to pay attention. And so spend a few minutes thinking about what prevents you from listening. One of the things that prevents me from listening is just being distracted, right? I've heard my phone beep a couple of times, and then all of a sudden, even while I'm giving the lecture, I'm thinking, have I missed something? Is somebody trying to get in touch with me? Your phone's ringing. You know, maybe you're hungry, maybe you're thirsty, maybe you're tired. Listening and being an active listener is hard work, but you cannot get to a resolution for your client that makes sense if you haven't listened to them. Because again, go through today and think about what has happened when you don't listen. And some good points and tips are coming through on the chat tool. So I'm looking forward to reading those when I stop my PowerPoint. Make sure you're giving good eye contact. I find sometimes, especially when I'm tired or at the end of the day, it's hard to pay attention. You're thinking about, what am I going to do for dinner? I've had such a long day. I just can't wait to get home and relax. See my family when I get home. And so maybe you're not giving your full attention. But if you are giving eye contact, if you're paying attention with your body language, a lot of times that'll take you and give you that extra energy to really pay attention and to listen. Acknowledge the emotion of your client. And again, you're going to have emotional clients, or you're going to have clients that should be expressing emotions and don't. So again, just giving that client, I hear the frustration in your voice. That you don't have to tell them that's a good or a bad way to be, but acknowledging what you're hearing. Telling them, again, summarizing what they've told you so they then can listen to you and will acknowledge that you heard them correctly. Ask them, did I get it right? That gives them the ability to correct your understanding. And this is really important too, especially if you're dealing with most of us. I would be surprised if it's any different in India. Most of my clients are not other lawyers. They are people with varying educational degrees and cultural backgrounds, maybe some language differences. And so what I heard may not be what they said. And asking them and giving them the power and the ability to correct you is really important. Restating it and reframing the issue is really important. And is there anything new that you want to tell me after that person has told the story? A really good, just a marketing technique, I've seen a lot of attorneys give out free notepads to their clients and say, if you do think of anything new, or maybe as we're going through some things, if you need to, if you think of something that you want to share with me, use this notepad. And maybe it's in the form of a journal, and they can keep that notepad to jot down things that are important to them. This is really important, to a good technique too. Make sure when you're at mediation, give that client a notepad and a pen for them to use throughout that mediation, so that they're able to jot some notes and write down some things. And listening, give ask the mediator to step out of the room and say, I've noticed you've been taking some notes. Is there anything new we need to talk about? And keeping that good engagement is really important, because the client's got to trust you. It's not your settlement, but you're there to help guide this process. And you're there to ensure that your client's best interests are being taken care of. So some of the filters that we have that prevent us from good listening are things, and these are the top 5 things that prevent us from listening, and we all have them. So perceptions, right? So maybe you have a gender perception that women don't listen and that they talk all the time. Some perception, children aren't good listeners. They're not going to tell you anything that you need to pay attention to. You already know everything that person's going to tell you. So sometimes that prevents you, your perceptions, your biases prevent you from listening, or puts a filter on what you may be hearing. If you're angry, it is difficult to listen. If you're tired, frustrated, any of your emotions. This is really hard, I think, for attorneys, because we're human beings, and we are going to have bad days, and then we have to go to a mediation and listen to our clients or talk to our clients in the interview. And so being able to set aside your own emotions so that does not prevent you from listening. The common phrase is familiarity breeds contempt, and I think sometimes we tend not to listen as intensely to the people that we spend the most time with. We think maybe they're not going to tell us anything new, or we can take them for advantage. So remember that sometimes that familiarity causes a breakdown in listening. It's also important to point that out gently to your client, because they're going to need to listen at some point to what their spouse, former spouse, significant other in a family case is going to say. If somebody is not comfortable, that impacts their ability to listen. We all have heard that saying that the brain can only process what the rear end can endure. And what that means is, if your client's sitting in a chair for 8 hours in a mediation, sometimes they're unable to actually process what's happening. To make sure, again, not only the table is comfortable, the chairs are comfortable, and that if you need to take a food break, maybe your blood sugar is low, need to take fresh air. We talked last time about taking a walk around the block with the mediator to change kind of the view of the participants. So making sure that the room isn't too hot or too cold can sometimes impact the ability to listen. And just all these internal filters, right? So this constant chatter in your mind. Oh, I'm running late. I've got to go do this. I need to run this errand. I've got to go to the grocery store. I've got to make dinner. Oh, I've got all this coming up on the weekend. How am I ever going to get all of this work done? That we call it, my yoga teacher calls it the monkey mind, that's constantly just chattering inside. And if I'm having a lot of internal chatter, it's really hard for me to pay attention and to listen and to process. So, run through this list of listening filters, things that prevent you from listening, and also talk about these things with your client, because it is really important that your client is also going to be able to listen when he or she is at the mediation table. And then one final note that we're all trying to get the mediator and the counsel and the parties, we're all trying to get this enforceable settlement. So hopefully, once you've followed all those previous rules, this won't be a question. But again, making sure that once you have a settlement, it can be enforced. Sometimes what happens, people are it's the end of the day and they realize, oh, it's Tuesday. If I don't resolve this case today, I'm going to be in court Monday morning, and I need to go ahead and get this done because I want this settlement done. So making sure that when an agreement has been reached, that you know all the details are addressed. And so I think sometimes having that limited discovery at the beginning and having that professional come in and talk about this is the value of the home can help you get this settlement detailed. We had talked before about carrying a potential or a template draft settlement agreement so that you know all the details that you want to work out, all of the issues. Because sometimes what happens is people are hungry, they're tired, and you've got this compromise mentality, and the people are like, I just want this done, I'll agree to this. And then once that settlement's in place, all of a sudden the client realizes, well, I don't know why I agreed to having the children on this particular day because I work every Thursday. And so having that conversation and making sure that every part of the settlement makes sense is important. And so having all of these things, the question should be, how do you make sure that you and your client are ready to draft the settlement agreement? And I think the simple answer is all of these things are important and factor into making sure that all of the details are addressed and that they're a realistic resolution. And so we have reached, again, the end of the hour. Here's my email address. I welcome any comments, any questions, any requests. We've got two more, Mr. Moore.
No, ma'am.
Two more sessions. Yes. So two more sessions. So please feel free to give me an email and let me know what you're thinking about the topics. And if you have any questions about what we talked about today, I'm going to look at the chat. I really appreciated all the questions and involvement. But any questions from today?
Ma'am, you talk about biases. Now, biases, do you mean if I have a personality, I have certain, I have certain beliefs. So whether that beliefs would, impact my mediation or, it will affect me in a way in which I will not be in a position to mediate the matter properly. And do you asking me to, look after that personality means I have certain faith, I have certain beliefs, and those beliefs are going to affect the way I mediate. So this is what bias you were talking about in mediation.
So bias is different from a belief, and bias would be this perception that things are one way. So if you believe that only boys should play sports and only girls should play with dolls, and you see a boy playing with a doll, and you treat that boy differently because that's a perception that you have. That would be a bias. So you would have a bias against that boy playing with a doll. That's different from your religious, political, moral beliefs, right?
Right.
And
How
so,
we are going to challenge that thing means how if I have certain beliefs, belief is not in that sense. Belief means I have certain perceptions. How as an individual I could challenge that thing when I am mediator.
so your mediator needs to be very candid, and if you're mediating a case where you believe, so let's say that your belief is that women who commit adultery are should not get children because they're immoral people, and you should, if you cannot set aside that belief, that bias against that female, that woman who has been accused of adultery, then that mediator cannot be that fair and impartial neutral, because they're going, and if you cannot set aside that belief, what counsel needs to be aware of is if they also share that belief and they're not aware of it. A lot of times we have beliefs or biases that we're not aware of, and we may act out of those biases unconsciously, right? So a lot of times it might revolve around gender or race. If you think that a certain race is not as smart or not as deserving, sometimes that's an implicit bias, and it could potentially manifest itself in a way that you as counsel are not as vigorous an advocate, as zealous an advocate for your client, because you think that person deserves less than someone else. Did that answer your question?
Yes, ma'am. Apart from that, do you believe the course, 45-hour mediation course, is somehow dealing with that aspect that my perspective, whatever perspective I might be having relating to the thing, I should be in a position to keep it aside. I should be in a position to keep it aside and deal with the matter neutrally. So, is there any provision, any course curriculum that has been created, which forced us to think in that specific way?
Yeah. So most mediation, the 40-hour mediation training for certification includes some discussion of bias, and bias on behalf of the mediator and bias on behalf of the parties, right? So because again, getting the parties, the mediator should be free from bias that affects his or her ability to be that process manager, right? Again, all of us have some bias, and it's whether or not that's going to affect your ability to be that neutral that the parties deserve. But it's also recognizing, it's the mediator's responsibility to recognize when bias is happening at the table. And, sometimes you may have this occur, not necessarily in family court mediations, but in business mediations where one party has a significant bargaining advantage over the other, and you see, a gender or a race bias that potentially is occurring, and it is the mediator's job to level and address that bias that's going on during that mediation.
Right. Anyone in?
Christy, I just
Yes.
wanted to know. Hello. Yeah, I wanted to know. Can in the cases of where just Mr. More just spoke about bias, can parties, if they feel that the mediator is biased, either of the party can ask for change of mediator halfway when they are just about to enter into some settlement and suddenly they feel that the mediator is biased? Can they ask for change of mediator?
And you should. You know, again, the mediator controls the process, and at any time, the parties can end the mediation if they feel that the process is not being held and conducted fairly and neutrally. And so, you know, that's a conversation and an awareness that counsel should be having. So if you notice again that the mediator, and again I've seen it most occur in with cases with race and gender, but you can have age bias too, where you know, perhaps in a domestic situation, you have a very young woman who is married to a very old man, and that common perception, that stereotype would be that she married him for his money, right? And so if you get the sense that the mediator is kind of buying into that stereotype, has that bias towards the young wife, then you need to have that conversation with the mediator and say, I feel that based upon your actions, you are biased against my client based upon this. And a good mediator will say, then should we reschedule? You know, there should be no ramifications through the court system for not mediating. What, again, this goes back to picking a mediator and having conversations before. That might be something that you could have established or known during your pre-mediation sessions with that mediator. When, you know, he or she said, oh, she's just a gold digger, or just married him for his money, or something like that, that could have alerted you that your client was going to suffer some consequences of the mediator's bias.
Okay,
Does that answer your question?
Yes, Christy, that's that. I just want to know, so will the subsequent appointed mediator can take away the case or the mediation from there on, or he has to
Say that
start
one more time.
afresh? No, I'm in a present situation. If a mediator is biased and has finished a settlement halfway, can a subsequent mediator can take away, or he has to start the process afresh?
So I have mediated cases that have been mediated before and just they were not ready for settlement for whatever reason. No nefarious activity on behalf of anybody, just didn't settle for a variety of reasons we've talked about. And what I typically do is, you know, I'll do all of the procedural matters, but I'll ask, are we going to start where you last stopped? And so have you already reduced some of the issues to writing? Do we need to review any of that? And so typically I'll start where that mediator finished. And so that's appropriate. I do believe that in order to protect the integrity of the process should start over, just to outline like the opening so that mediator understands where we are. You may not need to do it as long because you've already established some ground. and you already know basically where you are. And again, remember, the mediator facilitates the process. So if you're already able to get to a writing, maybe you don't need the mediator to just finalize the settlement.
Okay, that's clear my doubt. Thank you.
Thank you. All right. I tell you, these are the quickest hours. Time just flies by. I hope it flies by for y'all. Flies by for me. I was worried I didn't have enough slides today.
So, do we have any question?
Any more questions?
I think.
All right.
So, thank you very much, ma'am. It was a great session today.
Thank you. Thank you. All right. Well, I will see you on Friday evening. Have a great rest of your week. Bye-bye.
We declare the closure of program. Thank you very much, everyone.